most people don't realize is that they've filled out a series of beneficiary designation forms on their retirement accounts, and that those forms are going to govern the distribution of that account no matter what else happens to them in their life that may have a material impact on their wishes. They think, oh, I've been divorced and I changed my will to make sure my ex-spouse receives none of my assets. We also had a divorce agreement that made it quite clear that my ex-spouse was not to receive any of my 401k account. But guess what? If this person forgot to change the form, then that first designation is what's going to control, not the will. Largely, there are two reasons. Increasingly, financial institutions are encouraging legislatures to pass statutes that hold that the form governs over any provision in the will. With respect to retirement accounts that are provided by employers, those are governed by federal law called ERISA, and the Supreme Court has interpreted ERISA to hold that the form controls no matter what, even if there's a state law that would change the result. We do have state statutes that save people from themselves when they forget to update their estate planning documents. But when it comes to a 401k, those state statutes cannot be used. A court cannot invoke those statutes to effectuate the account holder's intent, because the Supreme Court has ruled that those state statutes are not applicable to 401k accounts. Well, I think people need to understand that it's critically important that they keep a record of every retirement account that they have, and specifically whether they filled out a beneficiary designation form for any of these accounts. It's extraordinarily important to then see an attorney who will coordinate all of those different accounts into the estate plan, right? Because there are serious tax ramifications here as well. And the attorney wants to make sure that any potential tax savings that they're creating by in creating an estate plan are not undermined by the client, who then goes out and opens a new retirement account and forgets to consult the attorney. So consulting the attorney and providing that attorney with a very complete list of all accounts and all beneficiary designations is extremely important. And to be able to do that, you need to keep pretty good records of what those accounts are.